Hey everyone, it's Daniel Hoffman-Zinnel here with Keenan Crow, our Director of Policy and Advocacy, and we're doing this video sooner than we had anticipated because we've had some things happen this past week. So we're giving you an updated video to talk through what's happened this past week rather quickly, unfortunately, because we've had some things happen. So Keenan, tell us about all of the things that have happened this last week.
So you'll recall at the end of the video that we released at the beginning of last week that I had said no bills targeting the LGBTQ community were bad yet.
Keyword yet.
And we emphasized the yet, and that was good because a lot of them dropped, unfortunately, this week. So, among other things, there is a RFRA out on the House side, a religious exemption bill, which we've talked about a couple times before. If that starts to move, we will let you folks know. We'll get an action alert out there. Our current action alert, though, that's already out, and you folks can go and sign your name and tell the House Judiciary Committee what you think of the bill, is the Judicial Nominating Commission restructuring bill. So this is kind of a little bit esoteric because it's pretty far removed from what a lot of folks think about when they think of government. But these are the folks that choose the slate of judges that the governor then gets to choose from for the Supreme Court. And at the district level, they're also putting up slates of judges as well. Okay. So this bill will restructure the way that judges are selected statewide, pretty globally. And the problem with that is currently our system uses a merit selection process that uses members of the bar and appointees kind of in equal measure. Well, the members of the bar, a lot of them are going away and they're being replaced with, once again, political appointees. So this is going to inject more and more politics into the judiciary. Right now, Iowa's system is the envy of the nation. It is regularly in the top 5 judiciaries as communicated by the Chambers of Commerce across the U.S.
Touted as fair and impartial.
Absolutely, and is cited by all sorts of other courts across the country because of the quality of those judges that system produces. And so not only is the system not broken, it's actually really working good. Really well. Yeah. It's not that we need to not fix what's broken, it's that we need to keep what's really working well. And so we'll go ahead and put a link in the description here of this video so that you folks can hit that action alert if it's not already in your email. But definitely let your elected officials know you want to keep the current system that we have. It's working really well. And that's the system that the LGBTQ community has been able to excel in, right?
That's right.
It's a fair system, and our arguments are good enough to win in a fair system. Right. And that's essentially the argument that I made during committee. We'll show a quick clip of that here, and you can kind of see how that testimony goes. So we'll cut to that real quick.
Keenan Crow with One Iowa Action. We represent the LGBTQ community in Iowa. The core question I think we have to ask ourselves today, anytime we make changes to the judicial prohibition baskets, is this going to make things more fair? But unfortunately, that's not what I've heard today at all. Over and over, I hear folks complaining that there's a certain decision, this decision or that decision didn't go their way. But that's what happens in a fair system, right? Sometimes decisions don't go our way. That's how it's supposed to work. The response to that should not be to politicize the courts in order to get decisions that we want. That's not independence, and that's not fairness. The LGBTQ community has no doubt gotten some great decisions out of the courts, Barnum being the best one that we just heard about a little while ago. But we didn't get the Barnum decision by stacking the courts in our favor or politicizing the judiciary. We got the Barnum decision by having the best argument, and that was demonstrated by the unanimous ruling that cut across ideological lines. So we aren't asking today for a liberal judiciary or a pro-LGBTQ judiciary or anything like that. We're asking for a fair, impartial judiciary because we believe that our arguments are good enough to win under those circumstances. So if folks believe that their arguments are good enough to win in a fair and impartial judiciary, let's keep it fair and impartial. Selected by merit rather than politics, and qualifications rather than ideology. Let's give everybody a fair shot at justice. I urge you to reject this bill and keep our legacy as one of the top judiciaries in the country. Thanks.
Thank you, sir. Well, thanks for being up at the Capitol and sharing your insight.
Yes.
That was a great clip. So let's talk now about the free speech on college campuses.
Yes, absolutely. And for those free speech components, we like those. College administrators are sometimes a little iffy around controversial issues, and we would like groups and different folks to be able to express all their ideas freely on their campus. We have no objections to that. We really just have one objection to a single paragraph in that bill. And if you look the bill up, it's Section 3, subsection 3 of that bill. I believe the number is 1099. We'll throw a link in the description for that too. The deal with that is that is the subsection that allows campus groups to discriminate in their leadership while still receiving student funds. And the students all pay into those student funds. So, it's effectively making them pay for their own discrimination. Once again, essentially what I said in testimony, so we'll go to another quick clip.
Registered in opposition to the bill, but only because of one small section of the bill. That's Section 3, subsection 3. We have really no other objections. Our objection is simply this, that student groups should not be able to engage in discriminatory conduct on the basis of protected class status and still receive those student funds. Indeed, it forces students to pay to be discriminated against in this context, and we have therefore moved beyond the realm of free speech in this instance and into the realm of subsidized speech. We support the free speech components of this legislation. We do not support the subsidized speech components of this legislation. So I won't take a moment to acknowledge that ruling from yesterday, and I will quote Judge Rose's conclusion in full. The court suspects that some observers will portray this case as a fundamental conflict between non-discrimination laws and religious liberty. Appealing as that may be, it overinflates the issues before the court. The human rights policy at the University of Iowa promotes valuable goals for both the university and society at large. There is no fault to be found with the policy itself. But the Constitution does not tolerate the way the defendants chose to enforce the human rights policy, particularly when free speech is involved. The uneven application of any policy risks the most exacting standard of judicial scrutiny, which defendants have failed to withstand. So there really is no constitutional issue with the policy itself that we're talking about in this case, and therefore no need to remedy this on free speech grounds. That question was addressed by the court. The violation was the unequal application, not the policy. The next matter I think we have to get really clear on is that just allowing for groups to force adherence to a standard of conduct or belief, rather than a class standard, does not actually sidestep the issue of class-based discrimination at all. We have good evidence of this within Supreme Court jurisprudence. For instance, Ginsburg's opinion in CLS v. Martinez. The Christian Legal Society contends that it does not exclude individuals based on sexual orientation, but rather on the basis of a conjunction of conduct, and the belief of that conduct is not wrong. Our decisions have declined to distinguish between status and conduct in this context. Kennedy's opinion in Lawrence v. Texas. When homosexual conduct is made criminal by the law of the state, the declaration in and of itself is an invitation to subject homosexual persons to discrimination. Or O'Connor's concurrence on the same case stating that while it is true that the law applies only to conduct, the conduct targeted by this law is the conduct that is closely correlated with being homosexual. Under such circumstances, the law is targeted at more than conduct. It is instead directed toward gay persons as a class. Or Scalia in Bray v. Alexandria v. Women's Health Clinic. A tax on yarmulkes is a tax on Jews. Underscoring this, Ginsburg goes on to say in the CLS case, after CLS has proposed that Hague states permit a similar exclusion to this law because of belief, but forbid discrimination due to status, that, quote, if a hypothetical male superiority club barred a female student from running for its presidency, for example, how could the law school tell whether the group rejected her bid because of sex or because, by seeking to lead the club, she manifested a lack of belief in its fundamental philosophy? It's therefore well established that this sort of targeted conduct adherence policy can be used as a covert form of class discrimination. For these reasons, we would ask for an amendment to move Section 3, subsection 3 from the bill, because we believe it's unfair to ask different groups of students, whether they are gay or female or disabled or whatever, to subsidize groups that discriminate against them as a class.
So you just saw the clip and were able to better understand what's happening specifically with this free speech on college campuses and why we took the stand we did, and hopefully you can be engaged in the process as well. So next steps for how people can be engaged, they can talk to their legislators.
Absolutely. Follow the action alerts. We do have that action alert out for the judicial bill right now. We are waiting on the free speech bill because they have said that they're open to amendment language, and so we're going to work with them and see if we can get get a decent amendment out of that. If we can't, there'll be an action alert on that.
Yep.
And then RFRA, as soon as that moves, or if it moves, we're going to have an action alert on that as well. So stay tuned to your email. If you're not already signed up for those action alerts, go to oneiowaAction.org. Sign up for those action alerts, and that way you can be on that kind of rapid response team with us, talking to your legislators directly about those bills in a really timely fashion.
And then always check out our website and Facebook for updates. But we would encourage you to come to our Day on the Hill, which is Wednesday, February 27th.
Yes.
And that morning, we're going to be at the historical building providing some training so that you better understand how to talk to your legislators and the process of going about doing that. Potentially some of these bills will still be live, so we will be helping you prepare, or we'll prepare talking points for you to talk specifically about them. But if there are other things that come up in the meantime, we'll be encouraging you to talk to them as well.
Right. Yeah, and there are some good bills that are going to be coming up as well, so hopefully we'll be able to talk about those here in the near future. If you want a really cool One Iowa Action Ray Gun t-shirt, though, they will be given out at our Day on the Hill. If you want to ensure that we have your size, you need to get registered by Friday, February 15th. So
this Friday,
that's
February
right.
15th.
Absolutely. If you want that cool Ray Gun t-shirt, we will have extras and stuff like that, but if you really want to ensure your size, make sure that you register by then so that we ensure we have one for you, because we're really excited about those. So cool. So the other thing that's coming up this week is the Iowa Harm Reduction Coalition Day on the Hill has been rescheduled to this Wednesday, February 13th. So if you are interested in the syringe exchange legislation, which is in fact moving forward, it had its subcommittee already, and we're expecting that it will get through committee, and we're hopeful about its chances overall. So if you want to help push that forward, that's another opportunity to engage with your legislators as well.
Awesome. Thanks, Keenan.
Yep.
Thanks for tuning in. Until next time.